Hey everybody, Greg Siskind here. I'm joined by my colleague Johnna Bailey, who is a one of our our immigration lawyers that's good at everything. She does family employment. She's one of the lawyers on the impact litigation team. Johnna, what don't you do?
That covers it, right?
So anyway, I was in Germany last week at the AILA's Rome district chapter, which is for all the European-based U.S. immigration lawyers. So I wasn't here last week because it was about 3 in the morning or whatever what was in Germany when this call was happening. Much as I like being on, that was too much. But I'm glad to be joined by John again this week, and we have been talking about what we were going to talk about today, as far as news development. So, John, I guess the breaking news was on, unfortunate news on employment authorization. It's always bad news on employment authorization documents. Can you kind of tell us a little bit about what was announced today, and then we can talk a little bit about maybe what the future is of that announcement?
Yeah, sure. So to give some background so you understand what changed today is certain employment authorization categories have something called automatic extensions. That means if you file your I-765 before your current employment authorization expires, your employment automatically extends based on your application being filed with USCIS. And historically, there have been several categories that really benefit from this. That includes H-4 EADs, that includes categories like VAWA and people with pending adjustment applications, and TPS holders, and asylum seekers, and asylees, and refugees. And traditionally, that extension was 180 days. There were lawsuits during the COVID era because of how long those processing times were. It was taking more than 180 days for a decision on cases. So actually, the auto extension based on that litigation was then broadened to 540 days. And today, with no announcement, USCIS announced that the automatic extension of every category is ending, meaning you will not be continued to be authorized to work for your employer while you're waiting for USCIS to make a decision on your case. And this was announced today and is effective tomorrow. So there was no opportunity to quickly get in applications to make sure if you have an upcoming expiring employment authorization card, you could continue working. So it was kind of a big surprise and really, really detrimental, right? Like when all you're asking to do is to be authorized to work, be legally permitted to support yourself and your family. This kind of was a big, big blow to a lot of different categories of those who benefited from this.
Yeah. So, John, I'm a little confused by this policy because my recollection is there was a regulation that went into effect in December that actually put this into the regulations. I'm looking at a Federal Register notice from December 13, 2024. Increase of the automatic extension period of employment authorization and documentation for certain employment authorization document renewal. So this is announcing this final rule amends DHS regulations to permanently increase the automatic extension period for expiring employment authorization or EADs for certain renewal applicants who have filed Form I-765 from up to 180 days to up to 540 days. So how does I guess this is sort of where we put on our impact litigation hats. It seems like you can't just take a regulation, especially one that was recently finalized when they went through all of the steps, and then basically kill that regulation without a new regulation at all, and just basically based on an announcement, just decide to ignore it. That seems like that is litigation bait.
It really does. And it kind of seems like that was the voice missing in the room as this decision was being made, the person to raise their hand and say, can we review what we put out? Well, not what we, but what was codified in regulation in December of last year. So it's almost like you're challenging USCIS can't just do whatever they want, because that a little bit feels like what they think they do.
And they tried that. I mean, look, they were even trying, I mean, they were trying to do this kind of thing in the first Trump administration, and it almost always didn't work because I mean, that was the whole point of getting this regulation finalized in December, getting these things done, because it makes it, where to undo this regulation, you have to do it through a new regulation. And you have to then go also, as part of that, explain why the old regulation was problematic. You can't just make an announcement and say, we're not honoring that regulation anymore just because we don't like it. So that seems like a conversation that is probably going to be happening fairly soon amongst the entities that litigate this kind of stuff, to make sure that it gets challenged quickly. But that's obviously not good news. I think that it could be challenged by somebody who maybe files for an I-765 and gets denied, and can just go in their individual case, go to a district court and say, have them rule that the policy is illegal. But it's probably going to be some type of mass action, if I had to guess, that's going to happen for it. So stay tuned for news on that. But that is in effect as of tomorrow. So if you I guess if you can get an I-765 filed online tonight, you still are covered. So we'll forgive you if you drop off this call and file that 765 application now. Go do it tonight on there, and then you don't have to worry about this regulation, or not this lack of regulation policy announcement affecting you. So that was bad piece of news number one. What is bad piece of news number two that you have on your list, Johnna?
Well, I think this is something that's kind of ongoing. This isn't necessarily new this week. I think this was something amongst the attorneys we are spotting, and many immigration attorneys are spotting nationally. This is the, let's say, reinterpretation of the 60-day grace period for H-1B holders. So Greg and I had discussed this in advance of tonight's call, and kind of the trend of what we are seeing is, if an H-1B holder is laid off or terminated, they traditionally have had a 60-day grace period to find a new employer, and that employer can utilize those 60 days to file a new petition and do that process from the United States. And the kind of trend we are seeing are H-1B holders that are being terminated from their job are then being either issued an NTA right away. When I say an NTA, that's a notice to appear, which is the document that brings you into court. Or even more sneaky is, if your new employer files a petition, they are flagging that petition to then issue a notice to appear. And the argument the department is using in immigration court proceedings is that 60-day grace period is a discretionary period, and they are not acting in their discretion to grant you that 60-day grace period. So you are then out of a status on the date of your termination, and you are not eligible for any kind of change of status in the United States.
So, we talked about this as well. I mean, there's language in there that says basically that says the quote, I think, is DHS may eliminate or shorten the 60-day grace period as a matter of discretion. That's where the discretion is. It's not that there is a 60-day grace period that appears to be mandatory, but they have the discretion to shorten or eliminate the grace period on a case-by-case basis. So the question is whether, first of all, that's happening on a case-by-case basis, because if they have made this policy sort of uniform and they're not granting it at all, then it's not. Then they're not doing what the regulation requires them to do, which is to do an individual evaluation and be able to explain why they are not exercising discretion. They can't just like say, because we don't want to. That's not that's not going to pass muster. They have to actually explain what there were factors in this case that didn't merit it, which means they have to actually look at the facts and explain why the facts don't merit it, as opposed to just saying we're not exercising discretion here. The other thing is that it was being granted pretty much universally up until the Trump administration. So, and this has been around since 2017. This regulation was finalized in January 2017 that created the grace period. So, as part of the requirements of the Administrative Procedures Act, which the administration doesn't always seem to like to follow that, you can't just basically change the way you do things in a arbitrary or capricious way, or using what's called animus in making a policy change just to be mean. On there, they have to actually explain why there were like legitimate policy reasons justifying it. And I think, there will likely be, I don't know when it'll be, but there's likely going to be litigation on that issue as well. And I'm guessing it's probably going to be attacked on that basis, that just because they have the discretion in some cases to shorten the period or not grant the grace period, if they can show that there's some public policy reason why it wouldn't be granted. The fact that it almost never happens, and it's never happened, that they have to show why they are varying from the pattern and practices of the agency over the years without any kind of policy announcement or any explanation for what they're doing. And they haven't issued anything publicly on the grace period since it came out. So my guess is lawyers that want to sue on that, you probably have something that you can sue on.
Yeah, I'm just imagining some interesting FOIA requests. Like, how do you target that FOIA request to show that, there's no case-by-case analysis to not explain?
So that might be an interesting exercise for the FOIA fanatics that are out there. And there's a bunch of AO lawyers that I know that love FOIAs on there, and they're super easy to file now because of the electronic filing system for FOIAs. So that happened. Johnna, let's update folks on the H-1Bs for the proclamation issue. Well, first of all, let me just back up before that. We had the deadline passed on October 24th for comments on the H-1B proposed rule. So this is one that it is proposed, and in theory, they're supposed to pay attention to comments, and I'm sure they got quite a few comments on there. But just to remind people what this proposed rule does. So basically, the way it works is it is change. You know how like they basically just changed the H-1B lottery rules to prevent people from essentially filing multiple applications through different employers in order to improve their odds, and that's why they went to a beneficiary lottery instead of a petitioner lottery. Anyway, all that was designed to prevent gaming of the system, and now the administration has proposed a rule that actually creates gaming in the system. And the way that they're doing it is based on wages. And so folks that know about H-1Bs know you have to pay the prevailing wage to the worker that you're hiring, which means that you're paying at least as much as somebody at that level of a position would be paid in that local geographic area for that particular occupation. And they use, and you have to show that this is an entry-level position or it requires higher, and there's basically 4 levels for the position, from entry level through level 4, which is for the most experienced quartile, I guess, is what they use. And for that, you have a wage set. The Department of Labor sets a prevailing wage at each one of those levels. So there's a level 1 wage, level 2, level 3, level 4, depending on how much experience is required for the job. The proposed rule would set basically a way to improve your odds if you're at a level 4 wage versus level 3, level 2, or level 1. So level 4 employers that are paying level 4 wages to a worker get 4 entries for that person. If it's level 3, they get 3 entries for that person. If it's level 2, they get 2 entries. And if it's level 1, they get 1 entry, which sounds nice and simple as far as how that works. But basically, the problem with this is that it essentially, for certain kinds of occupations and for certain types of needs, level 1 is what is appropriate, and it's what employers are able to pay. So this might be, for example, a physician, an H-1B physician that's just coming out of residency training is not going to be paid at level 4 for a physician who has basically been practicing medicine for 30 years on there, and they're working in rural areas, and they're doing primary care work or working in emergency rooms or whatever they're doing. So this sort of arbitrarily drives up the cost for those communities hiring a doctor and paying them at a wage level that's not really appropriate for what the doctors actually would normally be paid for that kind of position. Or, a school is in a rural area, decides that they need to have a math teacher, and they can't find U.S. teachers to teach math in the middle of this, of this rural community. Now, they would have to pay the equivalent of what they would, a teacher who's been teaching for 20 years is going to be paid instead of level 1, even though this person that they're hiring may be just right out of a brand new teacher in another country that's being brought in to do that. So it's problematic. And, yes, it's obviously it's great if to encourage employers to pay higher salaries in order to keep wages up, but it's not always appropriate that it be done that way. So that is anyway, that's what this rule does, and it's not final yet, but I'm pretty sure they're going to push this out quickly because they want to have it in place before the lottery that's coming up in February or March, rather, the lottery, but the on there that's coming up next. So that doesn't give them a lot of time because that's 5 months away for that lottery right now. So my guess is we're going to probably see this thing finalized in the next month, maybe 2 months, which also makes it subject to challenge if it appears like they're rushing it out and they haven't really given adequate consideration to the comments. But I'm pretty sure we're going to see this rule issued probably with almost no changes, just based on how things work with this administration. So expect that to happen. And I think immigration lawyers should start counseling their clients to assume that's going to happen. Of course, it may not matter how many entries you get if you have to pay $100,000 a tax on top of it. So you may, if you can afford that, or you have some basis for not being covered by the proclamation, maybe you don't have to worry about it too much. But that is, I think that's sort of a good way to transition into the other subject we were going to talk about, which is the H-1B proclamation. So, Johnna, we had I don't know if you talked about it last week or not, or if anybody talked about it, but why don't we just mention that there's a second lawsuit that was filed aside from the one that we worked on. And this is the Chamber of Commerce lawsuit that was filed in DC. There was news on, I can talk about the news on it if you want, but I think first of all, they got a judge in that case, Beryl Howell, who is not the easiest judge on there. So I'm,
That's what our partner said. So they.
Yeah. So Beryl Howell is she's trying to think. She's an Obama appointee, but you can't really always tell how a judge is based on who appointed them. They're not partisan. They are their own, and so she's just known as being kind of a tough judge on there. So I wouldn't make any assumptions about the odds are based on who appointed in this particular case. But that is one one thing. But they did file their preliminary injunction a couple days ago after adding. I don't know if they did it through the universities joined that lawsuit, and I think they are largely the basis for the injunction request, because they are filing H-1Bs now, unlike the private employer, the for-profit or the employers, and the employers that are not cap exempt. They're going to be filing in a couple months. They are filing H-1Bs, and they are getting requests for evidence now. So that's largely the basis of that claim. We can't talk about specifics on our case as far as timing, but I can tell you that we are working on what's on our what filing is going to happen next, and we are not we're certainly not going to talk about the litigation strategy on a live stream that can be viewed by the government. But I can tell you that hopefully there will be news shortly. And we'll also see what the government's positions are when they file a response, which is due very shortly in the DC case. So both cases are moving, and it is good news that we have cases going in two different courts on there, because they may not, the judges may come to different conclusions, and they can limit a injunction potentially to the specific plaintiffs in a case, and there's different results that could happen depending on it. So having a second suit, I think, is a good thing. The other thing that we started seeing this week are requests for evidence. I guess that's I'm trying to think, on the Thursday. The first example I saw was last Thursday of a request of a RFE on this particular issue, and now I've heard just personally about 3 others since then. So I'll just kind of like give a little bit of a flavor for what they were. One was a doctor, a Canadian doctor, who had a H1, who was on a J1. They didn't find a position till late in. They got started looking late, and they didn't get their J1 waiver paperwork finished before the end of the residency program. And the residency programs all end in late June. So the doctor went back to Canada to wait out the waiver, as is not unusual when that happens. And sometimes doctors will extend to take their boards, except the boards are generally all happen in September, October. So a lot of them will leave the country after that. But in any case, the doctor is not in J status. The J status was over. The doctor left the country. The waiver has been approved. The employer filed an H-1B, and voila, got an RFE asking for $100,000 for this doctor to be able to enter the U.S. to go work at the rural hospital that's already been approved for the J1 waiver. That's not a rare example, but that happened this week. There was another I heard as well about a doctor in the that got that was in a different part of the country that also got the RFE this week on a similar ground. And then I heard from a friend who has a this was sort of I'm not sure if this is contradicting the initial communications from the White House about how the order was being interpreted, but this is somebody who had an H-1B about 6 months ago that was approved. And then they ended up, they were outside the country, had an approved H-1B, but decided they didn't want to go work for that employer. And then had another employer file an H-1B for them after September 21st. And that got approved. And then they went, well, actually, it didn't get approved. They got an RFE this week asking for $100,000 and apparently didn't honor the fact that they had a previously approved I-129. And I think their position is that that only works if you're entering the U.S. Or seeking a visa to come and work for the same employer. That was the subject of the initial one, but that's how the RFE is reading on it. So,
Greg, just for a clarifying question for myself, had the person already been to the U.S. for the first employer, or was
no, so they get approved for an H, and then they decide they don't want to work for that employer. So they file a second H-1B for a different employer, and then which I think actually works for purposes of not counting against the H-1B cap again.
It does.
They don't have to go through the lottery again.
Correct.
But apparently USCIS is taking the position that they're not grandfathered because they filed before September 21st, which seems to contradict the language from the first weekend saying that all you had to do was have an I-129 and that was filed for you. I don't think it says anything in that announcement, these initial announcements, that it had to be by the same employer, but that seems to be how USCIS is interpreting it, that you have to enter with. So, I mean, I guess in theory, if they decided they want to go and try and enter with that employer, and then leave and then try and file a change of employer within the United States, maybe that would work. That doesn't seem to make a lot of sense to me. That is how they interpret it, but that is what that's how that is looking. Then, actually. Yeah, so a couple things that most doctors are cap exempt as far as you would think, but that is not actually correct. There are a lot of doctors who are not cap exempt, but the ones who are cap exempt, and but that last one I was talking about, it actually is not a doctor. I don't know what occupation they're in, but the lawyer that told me about it doesn't do a lot of doctor cases, so I'm guessing it's probably not a doctor. But yes, that's the problem with doctors is if they can do the transition from J to H in the U.S., that will work. But doctors who get hardship waivers, J1 hardship waivers versus waivers based on federal agency or state health agency waivers, they have to consular process. They can't process through a change of status. So hardship waivers are over for doctors on there, because that's the only, they're automatically going to trigger the $100,000 fee, and then they have to get a national interest exemption, which was Shaw's second question, which is, have you seen any national interest exemptions? We have not. I haven't heard about any examples yet of a national interest exemption being actually granted. Johnna, have you seen any or heard about any?
Not yet. So I think that's what is the next phase of understanding the proclamation, is understanding what qualifies. And I think we only learn that by watching what is approved and what is not.
Yeah. So I was, I was thinking I was going to try and find the actual, I do have a couple of examples of these RFEs, and I wanted to, I've been wanting to kind of like sort of microscopically go over them. But it is they do indicate that you're supposed to apply according to the USCIS. Oh, this was the other part of it. So USCIS puts out this language about, this clarifying language about H-1B change of status and all that, but they also said you had to file for the national interest exemption and get that approved first before you actually file the I-129. And so we don't really know how that works, or whether you can request that in the RFE, where it's asking you to pay the $100,000 fee. So it's still not entirely clear to me how the application process works for NIEs. I was looking for the example of this RFE that came in, but I haven't found it yet. But that's so Johnna, do you have are you comfortable about how that process works yet?
Not quite. I know there are multiple steps that they're asking petitioners to document, but I've yet to do one, so I haven't really been paying a lot of attention to what documents are
Yeah,
needing.
for the most part, lawyers have been making the national interest exemption claims in the petitions that they've filed,
Mhm.
without actually getting any. I mean, some of those cases have been held up. My guess is now we're going to start to see RFEs on those cases saying pay us $100,000 fee, and then separate, but or demonstrate as part of the RFE response. I am looking for that document that came out on. I think I sent it on Thursday to you guys, but that's right now we have we don't have a lot of clarity on how this is working. So as far as those who ask how to file these things right now, I guess it depends on sort of like what day you're talking to USCIS on that, because it seems like they are not, they haven't yet to issue any clear instructions on the website or elsewhere on how one actually applies for it. Okay, Johnna, we had the only other thing I think we had on the list that I wanted to mention was this disturbing case in New Orleans for somebody who was deported to Laos. And that case was reported in Politico this week. And basically, a person who was deported to Laos by ICE, even though a judge ordered the government to keep him here in the U.S. And why did the judge order this person to be kept in the U.S.? Because the person has what the judge called a substantial claim of U.S. citizenship. And the article really doesn't kind of get into a lot of detail of the Politico article on how they make the claim. It has to do with his entry as a permanent resident, I think, before the age of 1. And there are some rules regarding the status that one has if you enter at that point, but you don't get the documentation that you would normally get about your claims to status in the United States. But apparently, this person asserts the claim that I'm a U.S. citizen. Judge asks why. The person explains why, or the lawyer explains why, and the judge said, "That sounds like you have a claim on there. I'm going to order the ICE to not deport you while we figure this out." And then ICE just ignored the judge and sent the person to Laos. So what is going to happen in that case is very interesting. It sort of reminds me of the Maryland case from a couple months ago. And ICE backed down and brought Abrego Garcia back to the United States. That was that case. And it seems like this is happening again. But probably, I think in this case, it's actually more serious because this person has if this person's actually a U.S. citizen and they were being forcibly removed from the United States, that's definitely, I think, going to make a judge less tolerant. But basically what the judge is either going to say is bring this person back now, or the judge is they can do that. They can, order the government to give this person whatever documentation, they have a claim to as a citizen, and say that has to be expedited so the person can re-enter as a U.S. citizen. I mean, the judge could do a lot of different things. Judge could also go after the lawyers if it looks like, and this is what was going on with the Maryland case, where the lawyers had to basically say, "Hey, we didn't tell them to do this on there," and that was basically the only way that the lawyers didn't get a bar complaint, because the judge, the option for the judge is to basically refer the person for disciplinary proceedings, the ICE attorney, to the state bar wherever they happen to be barred, and that could be, who knows what state that's in, but that is judges do not like being ignored, particularly on something that has major consequences for the person that's the subject of being of what just happened. So we will see I'm going to be following that case pretty closely as far as like what's going to happen. But that's one that there have been instances of U.S. citizens that have been caught up in ICE raids and deported and all that. And generally speaking, ICE has been able to say, hey, we didn't know, they didn't have any documents on them or anything like that. But in this case, this is with the judge saying, hey, don't do this. And this person's probably a U.S. citizen. And that seems to me even more serious than just the random accidental removals of U.S. citizens on there, because in this case, ICE was on notice that this person was probably a U.S. citizen. So I don't know if you have any comments beyond that, Johnna, but that's obviously concerning, and we'll see where that goes.
It's this week's concern of due process, right? The individual has a claim to citizenship and didn't get a chance to present that, and didn't get a chance to present it because someone acted in violation of the judge's order. So
right, but it's even more than that, because the judge said, sure sounds like you have that claim. I mean, it wasn't just like this person saying, hey, I'm a citizen, and the judge saying, okay, we'll let you make that claim. We'll let you make those arguments on there, but I have not, I don't, good for you for making the claim. But in this case, the judge said, it sounds like you have a claim based on how you're describing why you have that. So that's worse than just basically, jumping the gun, ICE, and saying, and not giving a person the opportunity to make the claim. In this case, the judge already said they probably have a claim, which I would think is going to make the judge even angrier. I think this person's coming back.
Yeah, agreed.
And if not, I think that they are going to, she'll haul Tom home in, or, somebody and start really making ICE, putting them on the hot seat for this. So my guess is that they're not going to have a choice but to bring this person back to be able to argue the claim. All right. Johnna, I think I've run down my list. I don't know if you have others that you want to raise. I know that Shaw asked this question, aren't all J waivers the same? All J waivers are not the same. I wrote 2 books on this subject. There are lots of kinds of J1 waivers, and they have different rules for doctors. There are multiple J1. I mean, there's a lot of J1 waiver programs that are out there, and some of them come with certain benefits and rights, like the ones that are based on working in underserved areas. Others don't come with that. No objection letters, for example. A J1 who gets a no objection letter does not get is not entitled to H-1B status in the United States. So if the person has not, that would be an example of a case where a person might have to leave or not. But definitely for the hardship waivers, they're not treated the same way. Because there's a statutory provision, for the waiver. And the reason why I know about that statutory provision is I was involved in drafting that statutory language back in 2004, when that became the law regarding H-1B change of status. Because at that point, all doctors had to consular process, and it was a major pain in the neck. And we got that language added to make it easier for doctors to transition to H-1B without having to leave. Anyway, so
I did not know that, Greg. I think it's
also interesting on there, yeah. But you can barely see behind me a very thick black book that is on the top shelf of what you can see on the back behind me. That's a book called the J1 Visa Guidebook, which is like about a 1,500-page book that I co-authored for many, many years with Bill Stock and Stevie Allaire. And we get into all the different kinds of J1 waivers that there are. So.
Even within our own firm, J1 waivers are so diverse in the variety that we each specialize differently in the J1 waivers that we handle. So I handle J1 persecution and hardship waivers, but will be the first to not touch the other variety of waivers, and vice versa. So it's not even just the J1 waiver attorney. It's significantly differently enough that it's its own specialty. So Greg specializes in all of them and writes the book, while the rest of us practice them and practice them.
INA 212E starts out relatively, it's one paragraph in the statute on there about how this applies, but then there is endless regulations and memos and interpretations and agencies that have programs for it. So it's a great area of practice if you sort of like to get into the weeds, but on something that I think is really, the people that come in on J's are the greatest on there. So I'm happy that that we're able to help a lot of them benefit the U.S., but the administration apparently is less so on there. So hopefully we'll win our litigation so that we can, so that this is all a moot point. But anyway, I want to thank you guys for watching again this week. Next week, I hopefully will be doing this again. I'm not sure with who, but I am going to be attending the International Bar Association's annual meeting, which happens in Toronto. So at least I'll be on a time zone that's relatively consistent with what I'm used to. I'm the chair, I'm the co-chair rather, the junior co-chair this year of the International Bar Association's immigration section. In January, I will become the senior chair, co-chair of the IBA's immigration committee. So I will be doing lots of stuff this week that's with immigration lawyers from all over the world that meet up at this bigger conference with like 5,000 or 6,000 lawyers. That happens a different city in the world every year, and this year it happens to be close. So the fun fact is I get into Toronto on Saturday, and Toronto, if the Toronto Blue Jays are playing the I guess it's the Dodgers, they're playing the Dodgers in the World Series, and it's 2-2, and they if there is a game 7, it will be in Toronto on Saturday night, and I get in Saturday afternoon, and I'm staying like right near the baseball stadium. So I am like super excited that if the Toronto wins, I'll get to see all the big victory celebrations in the streets of Toronto on there. My timing is going to be good. But so next week, if I'm able to do this, it'll be from Toronto because that'll be Wednesday. Anyway, that's it. So thank you guys, and we'll see you next time. Bye-bye.